This meeting of the House Agriculture Committee will come to order. Austin Scott, will you start us with a prayer?
Yes, sir, Mr. Chairman. If you bow with me. Lord, we love you, and we know you love us. You've given us such a great country and such a privilege to serve, and we would just pray that you would give us the courage to do the things that would be right for driving this country in the right direction that would be pleasing to you. And we just ask that you bless every member of this committee and those who are here with us as we go forward and do our work. In Christ's name I pray, amen.
Thank you. Again, the committee will come to order. We're here today to review the 2015 agenda for the Commodities Futures Trading Commission. And Chairman Massett, thank you very much for coming and joining us today. We appreciate that. Today's hearing is the first of what I hope will be many productive engagements between you, your staff, your fellow commissioners, and members of this committee. I'd like to take a point of personal privilege. We spent part of Friday afternoon in Chicago with your team there, led by Rosemary Hollinger. Had a really terrific, productive 2.5 hours of exchange, and I want to also brag on Phyllis Dietz and Matt Hunter for helping out with that, and Corey Clausen, of course, and Ann Wright, and all the folks who helped us there in Chicago. It was a great 2.5 hours, and thank you for dedicating that time to us, and we really appreciate that. In 2015, the CFTC's response to the financial crisis is entering a new phase, shifting from the breakneck race to draft rules to a more deliberative implementation of those rules. It's inevitable that Congress and the Commission made mistakes along the way, and now's the time for us to step back and recognize improvements that can be made. Mr. Chairman, I'm pleased that you've re-examined some of the prior rulemakings to ensure that end users are not unduly burdened by these new rules. Your proposal on volumetric optionality exemptions, record-keeping requirements, and the residual interest deadlines are much appreciated. While we may not see eye to eye on all these details, the proposals meaningfully move the needle in the right direction. While continuing our long-standing focus on protecting end users, this committee will examine several broader issues this year. Specifically, we'll look at the swaps market under the new regulations, the position limit rulemaking, and the bona fide hedge exemption, the resolution of many cross-border jurisdictional issues that have come up, and the collection and usage of the tremendous volume of new data that's flowing into the Commission. Commissioner John Carlo recently authored a comprehensive white paper on the swap space and the SEF rules. Excuse me, I just asked you earlier not to use acronyms. The swap execution facility rules in particular. If someone with significant experience in that area, I appreciate his insight into these markets. Building new swaps exchanges and mandating centralized clearing and margining when feasible is at the heart of the reforms of the Title VII of Dodd-Frank. But it is important that changes to swaps markets recognize the gradual growth of these financial instruments. In a similar vein, as the Commission contemplates its position limits rule, it is not enough to regulate simply because the Commission has the power. The law directs the Commissions to set new position limits as appropriate and, as the Commission finds are necessary, to curtail excessive speculation. As the Commission moves forward, its proposed rule must first explain whether or not price movements in commodities are based on reasonable market forces and can be justified by facts, and then explain how position limits will diminish, eliminate, or prevent market disruptions. Big price swings, even those we've seen in the oil markets over the past decade, are not prima facie evidence for the appropriateness of or need for position limits. The Commodity Exchange Act also includes an expansive definition of bona fide hedging, which specifically includes anticipatory hedging needs. It's important that this exemption remain broad enough that legitimate commercial hedging activity can be sheltered from any limits the Commission may demonstrate are appropriate. On cross-border issues, it appears that there has been some tentative progress in reducing the ongoing tension with foreign regulators over how we apply national rules across international borders. Trust and mutual respect is a first step towards solving these difficult issues, so this is very welcome news. However, it's important the CFTC and the international regulators finish this important work and rebuild the fractured swaps markets. Finally, over the past few years, numerous witnesses have testified to the Commission's difficulty in collecting and using the tremendous volume of new data required under Dodd-Frank. This issue is critical to the functioning of swaps markets. Data reporting rules impose a burden on market participants, and those burdens cannot and must not be in vain. I know that the Commission is working to address this issue, and I look forward to your comments on its progress. In my view, these four issues present the biggest challenges in implementing Title VII with the least amount of additional disruption as possible. In the coming months, we'll be taking up the reauthorization of the CFTC, and the committee will look for broad input about how we can tailor and refine the law to ensure that the marketplace works for all participants. As we do so, Mr. Chairman, your perspective will be invaluable to our legislative process. And while, again, we won't agree on everything, we will work with you and your team to find common ground on improving the Commodities Exchange Act. Mr. Chairman, I look forward to working with you during the time we're privileged to work together. Again, thank you for appearing here today at this committee to share your views. We appreciate your time. And we now recognize the ranking member for his opening statement.
Thank you, Mr. Chairman, and good morning, everybody, and welcome Chairman Massett to the Agriculture Committee. This is the Chairman's first appearance before the committee, but I've had an opportunity to meet with him and have been impressed by his commitment to implementing the new regulations called for under Dodd-Frank and being inclusive of all points of view throughout that process. The rulemaking process has maybe taken longer than some would like, but given the limited resources they've had to get these rules in place, I think the CFTC has done a good job. I look forward to an update on the Commission's continued rulemaking as they go forward, and I believe that about 80% of the rules have been completed. I'd also be interested in hearing from the Chairman on some of the market issues that have recently made headlines. Has been mentioned before, one of the Agriculture Committee's top priorities for this year is to again pass legislation to reauthorize the CFTC. Last year we passed a good bipartisan bill that would protect farmers and ranchers who use the futures market to hedge against their risk. I hope that we can build on that legislation and get something signed into law this year. So with that, I thank the Chair and look forward to the Chairman's testimony. Yield back.
Thank you, Ranking Member. I'd like to welcome to the witness table the Honorable Timothy Massett, Chairman of the Commodities Futures Exchange Trading Commission of Washington, D.C. Chairman Massett, the floor is yours.
Thank you, Chairman Conaway, Ranking Member Peterson, and members of the committee. It is a privilege to testify today regarding the work of the Commodity Futures Trading Commission, and I am pleased to be here on behalf of the Commission. I also want to say that we were happy to host many of you in Chicago. I'm glad it was a productive visit, and we would be just as happy to do that in any of our other offices, including here in Washington, where we would be delighted if you wish to come over and we can make similar presentations or go into other areas. 8 months ago, 2 of the other commissioners and I took office, and today I'd just like to briefly review what the Commission has accomplished in that time and discuss some of our priorities going forward. I first just want to thank our staff for their hard work and dedication. I'm pleased that some of you had a chance to meet some of them. And I also want to thank each of my fellow commissioners for their efforts. And I think we're all working together in good faith to do the best job we can. The futures, options, and swaps markets are critical to our economy. They enable businesses of all types to manage commercial risk, whether it is a farmer locking in a price for his crops, a utility hedging the cost of fuel, or a manufacturer managing foreign currency risk. Our regulatory framework must make sure these markets work well for the businesses that need them. We must do all we can to prevent fraud and manipulation and to promote integrity and transparency. And our regulation must promote competition and innovation so these markets continue to thrive. Our agenda is focused on these goals. Let me highlight a few areas. The first is fine-tuning our rules so that commercial end users can continue to use these markets effectively and efficiently. Since last summer, we have made it a priority to listen to the concerns of end users, review our rules, and make adjustments where appropriate. We've taken a number of steps, including actions regarding margin and the posting of collateral, reporting and record keeping, and forward contracts, among others. There is more that we wish to do in this area, and we will continue to engage with market participants to make sure our regulatory framework is working for end users and protecting the public. A second priority is to continue implementation of the reforms to bring the swaps market out of the shadows. We have made good progress. Today, for example, in the markets we oversee, approximately 75% of swap transactions are being centrally cleared. That helps to manage risk and mitigate the adverse impacts should a default occur. But clearinghouses do not eliminate risk, so we must continue to ensure that clearinghouses have the resources and all the necessary safeguards to operate in a fair, transparent, and efficient manner. We are also looking at how our rules on swap trading can be improved to enhance further trading on swap execution facilities and to bring needed transparency to this market. And we will continue to work on a few of the Dodd-Frank rules that remain to be finalized, including the rule on margin for uncleared swaps, where we have exempted end users, and the position limits rule, where we must make sure end users can continue to engage in bona fide hedging. A third priority has been enforcement. Nothing is more important to maintaining the integrity of our markets and public confidence. Our cases cover a wide variety of market abuses and bad behavior, ranging from traditional Ponzi schemes and precious metal scams that target retirees to complex manipulation schemes driven by sophisticated high-frequency trading strategies, as well as price fixing or benchmark manipulation through collusion among some of the world's largest banks. From 2009 through 2014, the fines and penalties collected from CFTC enforcement matters were approximately twice our cumulative budgets. And already in this fiscal year, the fines and penalties collected are over 6 times our budget. These fines and penalties go directly to the U.S. Treasury. They are not available to fund our budget. A fourth priority is working with our international counterparts to harmonize rules as much as possible. I am personally committed to this effort. I've made many trips to Europe. I just came back from a trip to Asia, and we are making progress in many areas. And finally, we're focused on new challenges and risks. Cyber attacks are an increasingly significant risk to financial stability, and we must do all we can to enhance readiness, particularly when it comes to clearinghouses and exchanges, which are so critical to our financial system. We are also very focused on the increased use of automated trading strategies and their impacts on these markets. In all these areas, there is more we should be doing, but we are limited by our resources. Our budget simply has not kept up with the growth of the markets and our responsibilities. We cannot be as responsive as we wish to be. The United States has the best financial markets in the world, the most dynamic, innovative, competitive, and transparent. They have been an engine of our economic growth and prosperity. I look forward to working with you to ensure that this continues. Thank you again for inviting me today, and I look forward to your questions.
Okay, Mr. Chairman, thank you for being here. I'd like to start with a topic that's been in the news. One of the top regulators at the Bank of England yesterday confirmed that global swaps markets are fragmented. In your view, is fragmentation a problem and liquidity a problem in the swaps market?
Thank you for the question, Congressman. I think it's important to remember what a unique situation we have here. We have a swaps market which grew to be a global market before anyone regulated it. That's really unlike just about any other product I can think of. The G20 nations then came along and said, well, we need to bring this market out of the shadows. We'll agree on how to do it. But of course, the laws get implemented by individual nations. There are going to be differences, and those differences are going to lead to some fragmentation, at least in the short run. For example, the G20 nations all agreed to regulate trading, to require that trading move to regulated platforms. We were the first ones to do that. Nobody else has done it. To the extent that people can then trade outside of that, they are going to do so. But the point is that we're making very good progress in harmonizing these rules. Right now, we're very focused on issues such as clearinghouse regulation, where I think it's very important that we have cooperative supervision. I think we're making progress there. We're working on harmonizing the rules on margin for uncleared swaps. That's a very important rule, right? We've mandated clearing of standardized products, but a lot of swaps won't be cleared. They'll continue to be bilateral transactions. So margin, meaning taking of collateral from the counterparty, is very important to mitigating risk. Now, therefore, it's very important that we try to get the rules in the U.S., Europe, Asia, as similar as we can. And I think we're making good progress there. So my answer is we want to try to harmonize as much as possible, but people have to recognize this is a very unusual situation. It's going to take some time, and there are going to be some differences.
You either misquoted or quoted of saying that with respect to this that you needed some tweaking and fine-tuning. Is the issue broader than that, or is that to minimize how much harmonization needs to get done?
I'm not sure in which are you
We're
referring
talking about the fragmentation. You were quoted
Yeah.
saying this fragmentation, that the rules related or need tweaking and fine-tuning.
Well,
that's a bit of a...
Yeah. There's certainly some fine-tuning and tweaking that we want to do. Again, it sort of depends. I think you have to look at it in different areas. In the case of clearinghouse regulation, for example, what we're really focused on is working out arrangements so that we have cooperative supervision, for example. Meaning that I didn't think the answer there was to say, if the clearinghouse is in some other country, but they do a lot of U.S. business, let the other country regulate it, and we'll just, wait to hear from them. We felt that no, we've had a standard in this country where clearinghouses that do that kind of U.S. business have to register with us, have to meet our standards as well. We then try to work out arrangements so that our standards are harmonized with the foreign country standards. That's worked very successfully. The swaps market actually has grown to be a global market on that framework of dual registration. So I want to keep that in place. I want to work out cooperative supervision. On something like trading, the solution may be a little bit different. So it really depends on what area we're talking about. In margin for uncleared swaps, for example, we're trying to get the rules the same from the get-go. And again, I think we're going to make a lot of headway on that.
In the time left, talk to us about this, what appears to me to be a significant data fire hose coming at you with respect to the swaps and everything. And the comments made that the London whale issue at J.P. Morgan, that looking backwards at it, you couldn't find that whale within the data. How will the Commission use all of that significant data coming at you to good effect in order to warrant the cost of collecting?
Right. A very good question, Mr. Chairman. First of all, we're in a much better position than we were in 2008 already, right? In 2008, we had no visibility into this market. When AIG was teetering and the U.S. government ended up having to commit $182 billion to prevent its collapse, we knew very little about its swap activities that were taking place out from its London office, and regulators had to rush over the weekend to even understand what they were. We're a long way from that. Okay, we now have good information. To the extent we're clearing swaps, we get daily reports on the positions of the intermediaries. We're building this. Really, it's like an infrastructure project is the way to think about it. This is a massive effort to collect data on a market for which we previously had no data. It's a worldwide market. When you measure it by notional amount, worldwide it's 600 trillion, 700 trillion. I mean, these are huge numbers. So there's a lot of input there. And we need to have the technological resources to do that. That's why we're asking for them in our budget. There's a couple things that have to happen. We've got to harmonize standards. We're working very hard on that, both domestically and internationally. We're working to improve our rules where we can to make sure we're giving clear guidance and making clear what we want. If we don't get good data to begin with, we can't analyze it. And we're working to make sure market participants give us good data. But the key thing is really to have the resources to take this data in and then analyze it.
Thank you, Mr. Chairman. Recognize the ranking member for 5 minutes.
Thank you, Mr. Chairman. When we did Dodd-Frank, our part of the bill, one of the main things we did was, set up the clearing situation. And I read now, in different places, Financial Times and so forth, people worrying about that we're concentrating the risk in these clearing agencies. And is that true? And what are we doing to keep an eye on that so we don't just shift where the problem is to another place?
It's an excellent question, Congressman. The way I think about it is this. It was a good decision to mandate clearing of standardized products because that does give us a much better way to monitor this risk, to mitigate the consequences of a default, to understand where that risk is. But it's not a panacea. It doesn't eliminate the risk. So we have to be very vigilant in our oversight of clearinghouses. Now, we've had a framework in place for years that I think is an excellent framework. And, you know, today there's a lot of talk about, well, how exactly are we making sure clearinghouses are healthy and stable, and that's a very good public discussion to have. It's important to remember that these aren't banks. They're not the same model as banks. They're sort of institutions that mutualize the risk, and one of the keys is looking at the margin models to begin with as to what risk you take on. Another key is the surveillance we do. We do daily surveillance of what's going on in these clearinghouses, looking at what the clearing members, what their exposures are, looking at the clearinghouse health. We get a lot of financial information on a constant basis. And then there are issues pertaining to what we call the waterfall, making sure they have the resources necessary in the event there is a problem. Another big concern today is cyber. And this is an area where I really want to step up our efforts. I mean, the risk of a cyber attack to one of our clearinghouses, that's a very serious problem. And we want to make sure they're ready. So you're right. We need to be very focused on this. I think we've got a good framework in place, but we need to continue to be very proactive.
I agree. So thank you. The other question I have is, we have talked about this, you and I. You know, one of the things that my constituents are upset about is that, and all this stuff that's gone on, nobody has gone to jail. You know, and now, you know, it's become almost like, you know, we find, it isn't you, but somebody finds one of these big banks $9 billion and it just costs of doing business, you know. And I know that you don't have the criminal authority. I guess the SEC doesn't either. So you guys have to send this stuff to the Justice Department, I guess, and either it's too complicated, they don't understand it, or they've got other things to do, I'm not sure what. But, you know, people say, you know, there's probably some case for giving you more money. But frankly, my view is if we don't start sending some of these people to jail, you know, this commodity outfit in Iowa, whatever their name was, that went belly up, you know, my constituents, you know, that are just looking at the big picture, they think, you know, we haven't done anything about this. We just, you know, they're making so much money that they can just take these fines, these big, huge fines, and billions of dollars, and just keep on going. You know, I don't know what we do about this. But.
Congressman, I couldn't agree with you more. And we take criminal enforcement of the law very, very seriously. I appointed a former prosecutor as head of our enforcement division for precisely that reason, a guy who was involved participated with justice in the Oklahoma City bombing trials and other trials. We don't have the criminal authority ourselves. We have to work with our partners at the Justice Department as well as state law authorities. We're on the phone with them constantly on this issue.
Do you guys want the criminal authority?
Well, I'm happy to talk about that. That would be quite a change, I think, in our regulatory model in the U.S., and I have a lot of respect for our law enforcement authorities, and I think they're trying to do the best job they can. But, you know, our folks know that in each and every case they should consider whether there are potential criminal violation, because holding individuals accountable, putting people in jail, is one of the most important ways we can send a deterrent message. We've had, in the last fiscal year alone, we've had 12 cases that have resulted in federal criminal proceedings that grew out of our actions. There was a guy sentenced to 20 years for a commodity pool fraud. We had another guy sentenced to 16 years for a Ponzi scheme. We just had someone indicted for spoofing. So
that stuff never seems to get into the media, though, you know, and what gets in is a $9 billion fine on J.P. Morgan and whatever else that they do, and
right,
frustrates people. So thank you. My time has expired. Thank you very much.
Your time has expired. Mr. Nagelmeyer for 5 minutes.
Thank you, Mr. Chairman. And Chairman Sott, thank you for being here today. I was happy to hear yesterday that the Commission announced it will make changes to the margin rule after the bill, my TRIA bill, was reauthorized, and a provision was put in there to help clarify the end user. So thank you for that. I think one of the things that you probably have been hearing from this committee and from, I think, members of Congress is that we want to make sure we protect these end users and bona fide hedgers. And we want to, because these are people that are helping create jobs in the country. Along those same lines, one of the other issues is the position limits. And I think recently the Commission closed comments on a proposed rule on the position limits, further limiting the number of contracts that traders can hold. I've heard from some of my agricultural folks that, particularly from the cotton industry, that this is, and which is vitally important to my district, by the way, that the Commission's proposed rule do not adequately define what a bona fide hedging, what is a bona fide hedging, and what does consider a commercial market practices. And as a result of that, they think there is going to be some confusion about, and may some of these commercial entities that are working with producers, there could be limiting the ability of them to help manage those risks. Can you kind of discuss what the Commission is doing to make sure that we make that world big enough where our producers can use these marketing entities to help market their products?
Certainly, Congressman. It's an excellent question. And as you know, we've had position limits in place for agricultural commodities for many years. They've worked very well to limit excessive speculation. So I think they are an important tool in our toolkit, and Congress has mandated that we extend those to other commodities. But we must do that in a way that still allows commercial participants to engage in bona fide hedging. Now, that does get complicated as to exactly how you define that. We've taken a lot of input on this issue. We've had a lot of comments. I want to make sure we listen to market participants on this. Trading strategies are often very complex. At the same time, we need to write a rule that works here. So we're taking our time to try to get this right. And the staff is spending a lot of time sort of thinking about how we can craft these rules so that they work to meet the goal of Congress, which is to limit excessive speculation, at the same time as allow for bona fide hedging.
Yeah, I think in general, just on the position limits, certainly we want to have a situation where the bona fide hedgers have the ability to do that. But I think the other thing about position limits is we want to make sure that we provide enough liquidity in the market so that there is space on both sides of that trade.
Certainly. We're not trying to eliminate speculators. Speculators are part of the market. What we're trying to do is limit excessive speculation. So it's important that we get the levels right.
I was glad to hear you talk about cyber, and as the chair of Financial Institutions and Consumer Credit Subcommittee and Financial Services, that's kind of one of our priorities, beginning to look into that for two reasons. One, as you mentioned, to protect the overall infrastructure and the damage that can happen if we have an attack on some of these major entities that help clear all of our financial transactions on a daily basis. But also another piece of that is data. Security of the individuals, the amount of data that personal information and so forth, and proprietary information that many of these entities hold. Can you elaborate on things that your agency thinks that maybe needs to be happening, both from a government standpoint, but more importantly, I think it needs to also have a major private market participation in that as well.
Absolutely, Congressman, and you're absolutely right. It requires the private sector really to do a lot of the heavy lifting here. As an agency, we've taken a lot of steps. We've written in these kinds of issues into our core principles. The Congress, gave us a broad enough authority under the core principles to focus on cyber. We're focusing on this issue in our examinations, trying to make sure that the board of directors of these institutions is taking this issue seriously, that they've got policies in place, that they're following those policies, that they're responding adequately when there's an issue, an identification of a weakness. But we don't do independent testing. We don't have the budget for that. I mean, there are firms. I had a group of banks that I met with the other day, and I asked them how much they were spending on cyber relative to our budget. Told them what our budget was, and all of them said, "Oh, we're spending more than that just on cyber alone." One of them said, "We've got a cyber operations budget and we've got a cyber change budget, and both of them are multiples of your budget." That's the scale of the challenge here. one of the things we'd like to do with more resources is have the ability to increase our exams to make sure they're doing enough. One of the things I want to look at is simply standards that make sure private sector is engaging in adequate testing on their own. We're not going to do the testing, but show me that you've done the testing, whether it's through a third party or your own folks, and show me that you've then responded to the tests. That, I think, is the proper, role for an agency like ours in this kind of situation.
Thank you.
Ranking Member Scott, first 5 minutes.
Yeah, thank you very much, Mr. Chairman. Before I get to my questions, there are 2 points I really want to emphasize. First one is that I agree wholeheartedly with Chairman Peterson, and I would hope that the CFTC, we're your committee of jurisdiction, that you could report back to us with suggestions and recommendations of how we can strengthen your hand the best way so that we can put some of these crooks in jail. That is the most foremost way we can restore the confidence of the American people if they see them paying. Otherwise, they look at this as a cost of doing business. It's almost like the mob. They go murder somebody. They look at that as a cost of doing business. I'm not equating you with the mob. I'm just simply saying that this is where we are. But we've got to gain the confidence of the people back. Now, Mr. The other point I want to mention outside of that is your budget. And I just want to make an appeal to the Agriculture Committee. We are your committee of jurisdiction, and I would hope that we would be your champions. You need that full $322 million that is in that budget. Ladies and gentlemen of this committee, I've served on this committee for 13 years. I've been on this subcommittee for 13 years under this jurisdiction. I also serve on financial services. I helped write the Dodd-Frank bill, and especially that Section 7 on which you're coming under. Your workload is tremendous. The technology is changing. You've had burnout from your staff. Not giving you that $322 million is like putting you on the battlefield with your hands tied behind your back or cutting your legs off from under you and then criticizing you for being crippled. And this we do not need to do. So I hope that this committee will be a champion in this budget fight to give you that $322 million. Now, let me ask you this question, first of all, if I may. You're right now engaged in the very important negotiations between the United States and Europe on the regulatory harmonization. I wonder if you could give us an update real quick on that, because I have a couple of other questions, and how these agreements on these rules may be enforced once you do get the agreement.
Happy to do that, Congressman. I think it's helpful maybe just to take it area by area. With clearinghouse regulation, I talked a little bit about that earlier. What we're working on is just really formalizing arrangements that we've kind of followed on a practical basis for many years, meaning that with European clearinghouses, the bigger ones that do a lot of U.S. business, they've been registered with us, and we've worked with the regulators in Europe on cooperative supervision arrangements. And we're working that out as part of the arrangements whereby Europe, under their new rules, have a new standard whereby they have to recognize our clearinghouses. So we're looking at just formalizing some of the harmonization of our requirements. That's kind of what's going on in clearing regulation. In trading, as I mentioned, we implemented our rules. Most other jurisdictions haven't implemented rules yet. Europe's won't come on until 2017. So that piece is maybe on a slightly longer track. But in the meantime, we're going to be looking at our rules to see what we can do to enhance trading on CEFs.
Okay, but Mr. Chairman,
yeah.
I appreciate that. I've already, as Chairman told me, I had to be quick here. So
okay.
This other question is on cross-border.
Yeah.
Now, the CFTC has extended its no-action relief until September 30th for non-U.S. swap dealers for certain transaction-level requirements. and specifically where a non-U.S. swap dealer that is located in the United States arranges or negotiates or executes a transaction. As a result of that, many questions have been raised on where the CFTC should draw the line in determining its market participation will be subject to the cross-border oversight of the CFTC. Now, this no-action relief, to me, is a good thing. Gives you time, you get information, you get informed to do the job. But my point is, does the Commission anticipate formally revisiting this cross-border regime? And here is the kicker. Does the CFTC's extraterritorial approach create incentives for our United States businesses to move these jobs outside the United States in order to avoid this regulatory burden?
Congressman, we obviously don't want to cause business to go outside of our country, but ultimately what is needed here is the construction of this global framework for regulation and harmonization of that global framework, and it's going to take some time. As I noted, a lot of the European rules, and particularly in Asia, those rules aren't even online yet. In the meantime, though, we're trying to look at these issues and trying to think about the best way to address them. To give you an example, in the area of the margin for uncleared swaps rule, we said we didn't take a position yet on how that rule will apply cross-border. Instead, we laid out a couple of alternatives, and we invited comments on that from the public, and we're evaluating those comments now because, we could do something similar to what the bank regulators are proposing. We could do something similar to what our past guidance is, or there was even a third variation. So we're giving it a lot of thought. These are complex issues. I will say just one thing that I've said previously. I do think that when people are active in our country, when they're doing things in our country, that has been a traditional basis of jurisdiction. Mm-hmm. Then you have to think about, well, what does that jurisdiction then, what should it lead to? That's one issue. Second issue is Congress has told us that we need to think about the risk that offshore activity is imported into the U.S. and causes a problem. We saw that with AIG. All that activity was in London. Came back to really harm this country.
Well, okay, my time is well. Well, thank you, Mr. Chairman. I appreciate that.
Thank you.
I'll ask you about confidentiality and indemnification
okay.
on the side. Thank you, Mr. Chairman, for your general.
Chairman's time has expired. Chairman Lucas, 5 minutes.
Thank you, Mr. Chairman. And Chairman Massad, to follow up on Chairman Conaway's points and Mr. Scott's points, the issues dealing with harmonizing rules across borders, the letters dealing with the lack of action, all those things are really challenges to the industry trying to make sure that we have an effective process. And it's causing issues, as I understand it, in how business is conducted, the term fragmentation, loss of equity. But you mentioned, I think, to both of my colleagues that the Commission was looking at these issues as they unfold in Europe and as you address those. Tell me about the process when we go from simply the letters over to real regulatory framework. Are we going to use a formalized process? Will there be public notice? Will there be input opportunities?
Congressman, I'm very committed to the rulemaking process. I believe that the public comment is very helpful to us. As I said, we've got that process going on right now with the margin for uncleared swaps, where, again, we laid out options on how that rule could apply cross-border, and we invited comments.
Can you give us more of a timeline as to where, based on your observations of the Europeans, the action within the Commission, a timeline, a feel for what we can expect in the way of this being resolved?
It's going to take some time, is what I would say. This is a very complicated area. There are a lot of aspects to it. A lot of the other jurisdictions haven't even developed their rules yet. So this is not going to all get settled overnight. But we are making progress, and I think the markets are continuing to operate. We're doing the best we can with the resources we have and with the situation. But
you would agree the fragmentation issues, the loss of liquidity, those are real issues out there.
Well, I think we certainly want to try to minimize fragmentation and loss of liquidity. At the same time, we have to implement our laws. They have to implement their laws. As I said before, nations are going to have differences in their laws. You know, this is not unusual. Look at any other area of financial regulation. There are big differences in the laws. There are big differences as to how you sell securities in this country versus how you do it in other countries. Now, people have learned how to operate with that. But part of this is we're starting from this very unusual situation in which there is a global market that was never regulated. So people have a presumption that, well, all the rules should be automatically the same. Well, unless you want to invest, give the G20 the power to write our own laws, that's not going to happen overnight. I mean, again, we're trying to harmonize, but it will take time.
One last question, Mr. Chairman. I understand Chairman Conaway and Ranking Member Peterson sent you a letter recently noting that the prudential regulators are requiring supplemental leverage ratio and an inclusion of margin held by an FCM in the ratio on leverable funds. In the letter, they caution regulators that requiring financial institutions to hold additional capital to cover these non-existent leverage might drive up the cost of providing services through such an affiliate. Do you share what I believe to be legitimate concerns of the senior members of the committee?
I do share those concerns, Congressman. Thank you for the question. I'm very concerned that this could have a significant negative effect on clearing, and we have mandated clearing as a way to reduce and monitor and mitigate risk, and I think that was a good decision. I've spoken recently with Comptroller Curry and Chairman Grunberg at the FDIC as well as the Fed about this issue. We've agreed that our staffs would get together and discuss it further. I appreciate what they are trying to do with this rule. They're trying to create a leverage ratio. They are creating a leverage ratio that isn't risk-based, if you will, that doesn't turn on making risk measurements of particular activities. But when it comes to margin that is legally segregated, that is not available to a bank for any other purpose, that should be treated differently, in my view. So we will talk with them about it.
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
Gentleman yields back. Gentleman from Massachusetts, 5 minutes. That gentleman from Massachusetts.
Okay, yeah. I'm the only one.
Yeah. I know.
Yeah. Thank you. Thank you, Mr. Chairman, and thank you, Chairman Massett, for being here. And let me begin by saying I agree with Mr. Scott and with Mr. Peterson when I repeat what they said, and I think someone ought to go to jail. I think people are puzzled why that hasn't been the case. And I also agree with Mr. Scott in supporting the administration's budget request. Your agency is charged with policing the nation's financial sector and trying to prevent another economic crisis, and it is a big job. And the challenges of oversight get more and more complicated with every passing year. And the responsibilities that your agency have are enormous. We ought to give you the funds so that you can do your job, and your agency can do your job. Having said that, Mr. Chairman, I'd like to ask you about CFTC reauthorization efforts. I think we should be careful as we work on this legislation, taking into account the work CFTC has been doing since we last considered a reauthorization bill in this committee last spring. For example, as was mentioned before, I know the Commission has been working diligently on the cross-border issue, and we wouldn't want to hamstring its efforts and potentially delay critical progress. I also appreciate that CFTC has taken into account and acted on many of the end-user related provisions that were included in the committee's reauthorization bill. So as this committee looks toward CFTC reauthorization, I think we would appreciate any advice that you might want to provide us.
Thank you, Congressman, for the question, and thank you for your support of our budget and also your comments on enforcement. I obviously agree with those. I think you made the point well that, as I understand it, the well, there's been a lot of changes since the legislation that I saw, I guess, that was adopted by the House last year. We have, I think in that legislation, there were a number of provisions related to commercial end users. We've acted on a lot of those things, and I think I was sympathetic to the goals of some of those provisions in the legislation, but we felt it was better to address those things through regulation, so we've done so. I have some concerns on some of the other things that were raised in terms of process, changes in process of the Commission. I think some of those things could, frankly, make it a lot harder for us to do our job. So I'm certainly happy to work with the Commission on this and consider any approaches people have. But generally, I guess, to me, the real issue is, for us to do our job, we need the resources. It always comes back to the resources, not so much changes in the law.
No, and I appreciate that, and I don't want to take up any more time here, but I would again urge all my colleagues to understand that given the enormity of what you are being asked to do and your agency is being asked to do, that we need to make sure that the funding is there. Sometimes it's easy to criticize what you haven't done, but there needs to be an understanding that in order to do all this stuff, you need the resources and the staff in order to do the kind of job we all expect. So I thank you very much, and I yield back my time.
Jim yields back his time. Mr. Thompson for 5 minutes.
Chairman, thank you so much for being here, and thanks for the wealth of information and the wealth of hospitality that your staff showed members of this committee in our visit last week in Chicago. I want to follow up on Mr. McGovern was in terms of resources. I think one of the things that Congress can do to help free up resources at agencies is reduce the mandates or responsibilities that, quite frankly, are maybe no longer necessary or productive. And can you think of any obligations, reports, responsibilities, or others that Congress has mandated over the years at your agency that we that kind of have outlived their usefulness in terms of helping you fulfill your mission that we should consider eliminating during our reauthorization process?
Thank you for the question, Congressman. I certainly share the concern. Let me come back to you on that. Let me take a look. We are conducting a regulatory review to see if there are regulations on our books that have outlived their usefulness. It will take us some time to do that, but I certainly support, if we identify those things, moving to amend them or eliminate them. So if you would allow me to do so, let me kind of give that a little bit more thought and come back
absolutely. To you. I'm sure everyone on this committee would welcome, as you complete your process and as we prepare, if we could have that information, obviously, to do the best possible job in reauthorization to equip you going forward. The reporting rules were the first set of rules to be finalized, and much has been made of the Commission's difficulty consolidating and analyzing trade data. And last summer, the Commission solicited comment on potential improvements to the reporting rules. And I assume that many of the comments identified problems and suggested solutions. What does the Commission plan to do with the information received through this process, and when will plan be implemented?
Thank you for the question. We are thinking about that, and I'm hopeful that we will be taking some steps going forward. We're already taking some steps as a practical matter in terms of focusing on harmonizing the standards. We're working very hard, both domestically and internationally, to do that. We realize that, that's really a key, and we're taking a leadership role in that effort internationally. But we are looking at whether there are changes to our own rules that might be needed here. We're still completing that work. One of the things I've also asked our folks to do is simply look at all the data we're taking in and making sure that we even kind of have our arms around that and understand all the data we're taking in. How is it coming into us? How are we using it? Are different divisions, getting data that may be, requested in one area but might be useful in another. Once again, this comes back to resources. We get 300 million records of data each day. The types of data we're getting have dramatically increased, about sixfold. Our data storage needs are growing by about 35% a year. A lot of this is, records of trading. Now that there's more and more electronic trading, it's very sophisticated stuff. So, that's why we're asking a budget for a huge IT investment, because, we need to grow our capabilities.
And recognize, based on some questions from my colleagues, grow those IT technologies with higher cyber concerns as well.
Yes.
We had I think an economist in here last year that there was a question posed. I wanted to kind of pose the question to you. In your opinion, is an insurance product for futures customers a viable option? Why or why not?
Sorry, I'm not quite sure. An insurance product?
Product for future customers.
I guess I'd need to know a little bit more. Are you talking about an insurance fund?
Some type of a risk.
Commissioner Chilton's.
Are you talking about like a SIPC type arrangement?
Commissioner Chilton had previously weighed in on this.
Yeah, I think
risk management tool. Yeah,
I think the reference is to something similar to what we have in the securities world, SIPC, the Securities Investment Protection Corporation, and actually one of our commissioners is a former chair of that. It's something I'd be happy to look at. I don't have a view at this time, but I'd be happy to get back to you on that.
Okay. Thank you, Chairman.
Chairman's time has expired. Ms. Plaskett for 5 minutes.
Yes, thank you, Mr. Chairman, Ranking Member. Thank you so much for coming and speaking before us. Surprisingly, in the Virgin Islands, we have quite a number of hedge funds that are there, as well as asset managers. So we're really, as a territory, we're very happy for Dodd-Frank, as well as the work that you do that regulates a lot of these, because we don't want bad actors in our jurisdiction. And so I echo the refrain of so many of my colleagues here that we do believe that sufficient appropriation is necessary for you to be able to continue doing the work that you're doing. But because we have so many of these hedge funds, I wanted to ask you about consolidation and the growth of the hedge fund and asset managers in this area. And what are you doing, or have you thought about ways to incentivize others to come into this market as well? These are really dominant players in a lot of ways. And are you concerned about them as opposed to more regulated entities being involved in this area? And how are you trying to bring greater participation in the markets for other groups?
Congressman, thank you for the question. I think there's a number of aspects to that. Let me mention one, though, that we have been thinking about. There are a lot of funds today, hedge funds and otherwise, that are engaged in a lot of trading in our markets. It's electronic trading. It's often high-frequency trading. They're doing it for themselves, not for customers. So they're actually they don't really fall into a category in terms of, someone that we would normally say, well, you've got to register with us. And yet, these firms, they're very active in the treasury market and the equities market. Again, this is high frequency trading, a lot of messages all the time. I think one of the things we need to think about is, well, what about those firms? What about these proprietary trading firms? I've even had one or two tell me, you guys really probably should be regulating us more because they kind of want a framework too. So, that's, to your question, that's an example of something that we are thinking about.
And does that come along with your potential rulemaking that you think you may be coming out?
Well, again, this is kind of on the list of priorities. I got to tell you, frankly, this isn't. We have so many things on our plate. that you've reminded me of some conversations I've had, but we're not really this is probably it's not something that's certainly not something we're going to be acting on anytime soon. I think though it is a question. It really goes to how our markets have changed. CME closed the trading pits the other day, but the trading pits were no longer really relevant. But more and more of the activity is electronic. There's more high-frequency trading. Again, that's why we have to have very sophisticated technologies to keep up with it. But it really goes to the fact that as regulators, we have to work hard to keep up with how these markets are changing.
So my colleague reminded me, and I wanted to know if this was at all a priority or concern of yours. It had also been a discussion and oversight regarding cyber threats.
Yes.
Is that something that has a priority, or is it
yes.
high, low?
That is certainly a priority for us. We're very focused on that issue. We're highlighting it in our examinations, particularly of critical infrastructure like clearinghouses. We want to make sure that these institutions are taking this as seriously as they need to be, all the way up to the top.
And should that be a concern of ours in the appropriations
Absolutely.
For how much money you're receiving to be able to deal with that?
This is one of the biggest threats to financial stability today. So it very much should be.
Okay, thank you. I yield the balance of my time.
Gentlelady yields back. Austin Scott, who's the subcommittee chairman on the relevant subcommittee for today's hearing.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. And Mr. Chairman, I have an opening statement for the record that I'd like to submit. And thank you, Commissioner, for being here. And I'd like to follow up a little bit on what my colleague, Mr. Nagelbauer, discussed with you on the bona fide exemptions and the various rules with regard to position limits. And it seems to me that the bona fide exemptions rule that was in place was working, and the CFTC's put forward different proposals to change that. Where does the desire to change that come from if the prior rule was working?
Congressman, I think we're just trying to implement the congressional mandate here that we now have commission-adopted position limits in a number of categories, which also provide for bona fide hedging. And again, we're trying to write a rule that does reflect what Congress has directed us to do in that language. It is a complex area. That's why we're taking our time to try to get it right. Well, certainly our goal is to balance access with integrity, and what we don't want to do is to create restrictions to those who truly are hedging their risk in the markets. And so as you revisit this, certainly we'll be happy to work with you further on that. And if you feel that there's something that's congressionally mandated that maybe we could phrase better, we can certainly do that as we go through the reauthorization, and look forward to working with you on that. One other just kind of a quick question because of uncertainty in the date. The de minimis level for swap dealers, the drop from $8 billion to $3 billion. There's some confusion with regard to the date that would actually happen. Do you know the date that would happen and whether there was? Yes, sir. Yes, it would. It's under the rule. It would change in 2017. 2017. Okay. And do you expect public comment before that happens? Is this something that you think needs to be addressed in the reauthorization as we go forward? I don't know that I think it needs to be addressed in the reauthorization. What I would say is this. I think as with any issue under our jurisdiction, it's important that our rules and any decisions we make about the rules be based on good data and be based on good analysis. And we are required to do a study of this issue. We're going to do that study. I know all the commissioners will want to look at that and think about that as they think about this issue. So I can, assure you that any action we take will be I think will be based on good analysis and data.
Mr. Commissioner, let me just say this. I look forward to working with you and your staff and the other members of the committee on the reauthorization over the next few weeks. It's probably moved sooner rather than later, the way the House calendar seems to shake out. And as I said, our goal is to find that balance with access and integrity in the markets. And I certainly look forward to having you as a partner as we push forward with that.
Well, thank you, Congressman. I look forward to working with you also.
Thank you. Mr. Chairman, I yield the remainder.
Chairman yields back. Ms. Delbini for 5 minutes.
Thank you, Mr. Chair. And thank you for being here today and for your testimony. I offered an amendment which passed unanimously in last year's House-passed CFTC reauthorization bill, and it said that a court should uphold the CFTC's assessment of a cost-benefit analysis for a rule barring some sort of abuse of discretion. And I wanted to know if you could speak about the usefulness of this language in conjunction with including a cost-benefit analysis in a reauthorization bill as we look at that going forward.
Thank you, Congressman. That is the general standard that applies to our actions, so I think it is entirely appropriate that be the standard in the cost-benefit area also. And we have a requirement today that we do cost-benefit analysis in connection with any rulemaking. I think we do very robust analysis. We look at a variety of factors. And I think it's important to not try to get too specific or, be careful about how you craft the language in this area, because you can easily create unintended consequences that, frankly, make it harder, much harder for us to do our job, even in terms of fine-tuning a rule.
Mm-hmm. Okay, thank you. We've talked a lot about funding and the importance of funding, and you've talked about some of your priorities like cyber, et cetera. How helpful would it be to the agency's mission, to the rulemaking process, if we had authorization levels that were also included in a reauthorization bill? Does that help you out, or not?
I'm sorry, authorization levels in terms of our funding?
Right, for particular areas.
You mean sort of subcategories within our budget?
Mm-hmm.
I guess I would rather that, if I understand that maybe I need to talk with you further about it to make sure I understand. I'd like to see our budget grow. And, we've tried to lay out how we would spend that. We've laid it out very carefully, I think, in terms of our commitment to things like surveillance and enforcement and improving our data and technology capabilities. So I guess I'd want to understand how the authorization levels would play into that, and how they would help us meet those objectives. But my main concern is to try to get that budget up.
Right. Hey, thank you very much for your time today again, and Mr. Chair, I yield back.
Gentlelady yields back. Gentleman from California, Moffat, for 5 minutes.
Thank you, Mr. Chairman. Chairman Assad, welcome. Good to see you, and I appreciate your good work in your tenure so far. As you know, with Dodd-Frank's passage, publicly owned utilities had a negative impact from that as an unintended consequence, I hope, which put upon onerous and expensive reporting requirements on these utilities and the counterparties which they were engaged in their future purchases and swaps. So these requirements were so costly that many swap and future sellers simply stopped working with publicly owned utilities, putting them at a disadvantage to privately owned, and people that have no choice in their utilities were seeing that their access to energy futures were likely to have a lot of choices taken away from them. Ultimately, with less choices, higher costs to the ratepayers. So beginning of the 113th, I sponsored a bill, H.R. 1038, to place public utilities under the same rules as private utilities, which did pass in the House unanimously. The CFTC initially released a no-action letter to address the issue. The no-action letter failed to reassure the market, and therefore the CFTC then followed up with a revised rule similar to the bill H.R. 1038. So in the months since that rule was issued, I wonder how have you seen that the swap and future sellers have returned to the public utility market?
Thank you for the question, Congressman. Yes, we did amend our rules to address this problem. I'd have to check with our staff in terms of what we're hearing these days. I'm not hearing any loud complaints, so I'm thinking that the rule change is helping and addressing the need. But I'd be happy to get back to you.
Yeah, from your perspective, the information that we're receiving from our sources, that it has helped tremendously to get them back in the market. Do you think the rule change has increased the systemic risk or allowed the large swap dealers intended to be regulated by the Act to avoid oversight? Have you seen any negative effect of that?
Well, I think we crafted a rule change that appropriately balances our obligation to try to minimize systemic risk and bring the swaps market out of the shadows, but at the same time making sure that the companies that need to have access to these markets to hedge risk can do so and can do so efficiently. So, I think our rule change properly balances those issues.
I believe so too, because we haven't seen that anybody has been abusing the process or avoiding the oversight that I think we all believe is necessary and right. So, do you believe that going ahead and codifying this legislatively would be a useful step to ensure into the distant future that the rules cannot be changed again in a later regime, perhaps? Do you think that would be a useful step?
Well, Congressman, markets change frequently, all the time, in fact. And I think as a general matter, that's why we have, regulatory agencies and a legal framework given to those regulatory agencies, and then the regulatory agencies implement rules and revise those rules as needed. We may find a need that we, need to go back and fine-tune that rule or another rule. And I wouldn't want to see us try to codify what really should be done in regulations into law, because then it might make it that much harder for us to be responsive to the market.
Certainly, I understand that. Sometimes people on this side of the dais get a little spooked by the rulemaking that goes on in some areas of federal government, so we have to rein that in sometimes. But so far, we are pretty happy with the direction you've been taking things. So
thank you
for that, and look forward to working with you, Mr. Chairman. I yield back.
Jim yields back. Mr. Ashford for 5 minutes.
I think I don't really have any questions. I just want to, if I could, just make a brief comment. I'm new. You probably didn't know that, but I am new. But I from Nebraska, and most of us farmers or came from farms, and I grew up in a place where you would trade these commodities in a very different way than they are being traded now. I just want to comment that this is an amazing volume of work that's been done, and the work by the committee and the Congress and your commission is absolutely incredible. And the fact that we're talking about tweaking or making things better on a baseline is really very productive. And obviously, cybersecurity is very important. Trade could be, and I guess that's my question. If we had an attack of some kind on an exchange or on one of these sort of places that make these trades, how do you see? I mean, in a general sense, what sort of risks to a farmer in Nebraska would that potentially have?
Well, Congressman, thank you for the question. I think we're trying to minimize those risks, and obviously the industry participants are trying to minimize those risks. We all simply need to open the newspaper to see what kinds of consequences these attacks can have. We've seen it, with the loss of protection for confidential information, for personal information. But, when it comes to critical infrastructure, what you want to avoid is any kind of outage or stoppage. There have been technological glitches that weren't cyber attacks that have sometimes caused an interruption in trading. We want to avoid those too.
Which could, in fact, have an impact on the individual
absolutely.
farmer.
If someone can't trade, when they want to trade, that could hurt their ability to manage their own commercial risk.
Right.
So again, that's why these issues are so important.
And I look forward to talking more with you and learning more about it. But I will go back and tell my friends in Nebraska that we're well served from what I can tell in these matters. Thank you very much.
Chairman yields back. Mr. Crawford for 5 minutes.
Thank you, Mr. Chairman. And Mr. Chairman, thank you for being here. I understand the confidentiality and indemnification requirements in Sections 728 and 763 of Dodd-Frank were incorporated into the bill during the conference committee without any formal hearings on the topic and little time to fully vet the language or consider the unintended consequences. Can you walk us through how those provisions have impacted the CFTC's working relationships with foreign regulators and how those provisions might be negatively impacting regulators' ability to work together to identify and mitigate systemic risk on a global basis?
Thank you, Congressman. It's an excellent question. The provision you're referring to does provide that, as a general matter, certain types of data can't be shared with foreign regulators unless there is an indemnity that runs to us, as well as in some cases the swap data repository that's collecting the information. And the limitation that causes is we are again trying to build a global regulatory structure here, where regulators can work together to monitor the risks in this market. So it is something that people have suggested we should change, and I think that would be beneficial. Having said that, we're still very busy, and there's still plenty for us to do in terms of building this regulatory framework. Some other jurisdictions have their own issues in terms of privacy and their ability to share, which need to be addressed because sometimes they face restraints also on their ability to share data. So we're working through this. Happy to talk to you further about it, though.
Great. One more question. The Swap Data Repository and Clearinghouse Indemnification Correction Act passed the House last Congress and had 420 votes. The legislation becomes law. How would regulators' ability to monitor, detect, and mitigate global systemic risk be improved?
Congressman, if you would, I want to maybe just make sure I'm thinking of the right legislation, but let me just answer it more generally. If the legislation did remove this provision, this indemnification requirement, then it would facilitate the sharing of information across borders. Again, that would just make it easier for regulators to work together. Swap activity is, as we all know, global. Risks abroad can come back and hurt our country, and that's why working with our fellow regulators is very important. That's why we're putting a premium on doing that.
Excellent. Thank you. I yield back.
Jim yields back. Ms. Lujan Grisham for 5 minutes.
Thank you, Mr. Chairman, and thank you, Chairman Massad, for being here today. The state of New Mexico receives about $2 billion in direct revenue each year from energy taxes and royalties. And the oil and gas revenue accounts for approximately 30% of New Mexico's general fund. And this allows us to invest, of course, in infrastructure, public schools, and in other, particularly important to the state, but in my district as well, public welfare programs. And I'm concerned with the oil prices, which have dropped more than 50% since last June, and they're jeopardizing our ability to invest in education and any of our economic development programs. A $1 reduction in the price of oil reduces New Mexico state revenue from this direct source by $7.5 million. And in fact, as I understand it, our new revenue projections for this year have been cut by over 70% since the summer, from $286 million to $83 million. So it's clear that the price drop has been influenced, to me at least, by much more than supply and demand, giving that drastic a range. And just this Monday, the Bank for International Settlements, an international financial organization, published an initial report that found that the falling price of oil could have been caused by the energy sector's high debt levels and swap dealers' reluctance to offer hedges to oil producers during periods of high volatility. Now, I'm aware that the CFTC is currently looking at issuing new rules to limit speculation for certain markets such as energy, grain, and metals. Can you talk to me a little bit about the examination of this and what you've conducted regarding what kind of investigation during the recent oil drop?
Certainly, Congressman. It's an excellent question. The fall in oil prices has been dramatic, as you've noted. And so in the ordinary course of our surveillance, we are looking at this very closely. We've done a lot of work on it. And I'd be happy to maybe have our staff come up and talk to you more about kind of what we've seen in the market. We're very focused on looking at whether we see manipulative behavior. I would just say that the factors affecting supply and demand, of course, have been very dramatic. The shale revolution, as you know, the fact that we in this country now produce 9.2 million barrels of oil a day, more than our net imports. The fact that oil stocks are higher than they've ever been. I was in Asia a couple weeks ago, and people were pointing out to the harbor all the tankers that were just sitting there filled with oil, because that's how people are storing it. And the OPEC decisions, all these things I know you're very well aware of. But we will continue to look at this, and again, happy to have our surveillance folks come up and explain what we do and what we're seeing in the market.
I would really appreciate that. And while I agree with you that, given the current climate and given our production, there's tangible evidence that we can point to that gives us the fluctuation and certainly the drop in the prices per barrel of oil. But I'm also aware that there are other factors and don't want to be in a situation where they're completely mitigated by not evaluating them because we've got tangible evidence on the other side.
Yep.
And I'm also wondering whether or not that's affecting your analysis on commodity markets just in general, in the context of your examination of that rulemaking.
I'm sorry, if what is affecting our I didn't quite
your
follow.
Examination of not only just the tangible evidence of our oil production, so supply and demand,
Yeah.
but also that we've got, I'm hearing, and I think there is some evidence that would suggest that the hedges and speculation has some effect to what, and I want to understand exactly to what degree. Right. When you look at that, are you looking at those supply and demand issues as well as the investment issues related to commodities in general?
We have some pretty sophisticated surveillance techniques and data. We get a huge amount of data in every day, and we've computerized a lot of this analysis. So, we can look at what participants are in the market, what their positions are, whether they're, changing, whether they're long or short, the character of their trading. So we will continue to do that. We'll continue to be very, very active in this area. We recognize the importance of the oil market and the fact that this has been a very dramatic change, and it certainly will influence our thinking about policies and rules generally.
The chairman's always very patient with me. I'm always over time, and I'm going to take you up on your offer to come meet with me.
Fine.
Thank you.
Gentlelady's time has expired. Mr. Davis for 5 minutes.
Thank you, Mr. Chairman, and thank you, Chairman. I'm over here behind Mr. Rouser. Thank you to my colleague from North Carolina for giving me a vision. But I really appreciate that. Chairman, thank you for being here. You may recall last Congress I sent you a letter requesting that the CFTC address the real-time reporting rule on illiquid markets and end users who rely upon them to mitigate commercial risk. And recently the Commission offered no action relief to Southwest Airlines for its hedges in these illiquid markets. So I wanted to actually start off by thanking you and the Commission for recognizing that a commercial end user was being impacted unintentionally by Dodd-Frank and the CFTC's rules. Thank you for that. Do you know of any other market participants who face these same challenges that Southwest faced?
Thank you for the question, Congressman. At the time that we issued that letter, Southwest was the only one to come to us. I'd have to check with the staff as to whether anyone else has. But, I think the letter that we issued simply reflected the fact that the goal of transparency here is not to make it harder for companies to engage in the legitimate, hedging that they need to do. We're trying to balance, the goal of transparency with, in some cases in an illiquid market, real-time reporting can hurt that ability. And we'll continue to be mindful of that as we go forward if there are problems in other areas.
Well, I appreciate your willingness. I appreciate the Commission's willingness to do so, and I look forward to working with you if we're contacted by others impacted similarly to Southwest. I have concerns about the position limits rule, and particularly about the so-called conditional limit proposal. This could really have a substantial negative impact on the physically delivered market by means of lost liquidity and even higher volatility. I'm concerned about giving preference to some within the markets that could then hedge up to 5 times more, have more of a 5 times the opportunity in the spot month limit, and having that position that could impact seriously my farmers in the Midwest and those who rely upon the marketplace to get their products, their physically delivered products, out into the global marketplace. And can you explain the rationale that the CFTC is proposing this, why the CFTC is proposing this policy, and why it could have such negative consequences for our markets, and specifically the district I represent, how it could impact our agricultural and agribusiness end users who rely upon hedging?
Well, I think, Congressman, the conditional limits aspect of the rule is one of many aspects of the rule on which we've invited comment. There are conditional limits today, as you know, in certain energy futures. They've existed for some time, but this is a very complicated area. What you do affects different market participants differently. So again, we're inviting public comment on this and taking in that comment, and we haven't made a decision.
Okay, I appreciate your willingness to do so, and I look forward to working with you on that issue and making sure that my constituents' voices are heard. And one last question. I'd like to ask you about the CFTC Smart Check program. For those of my colleagues who aren't aware of it, it's a new national campaign intended to help investors identify and protect themselves against financial fraud. What is the estimated cost of Smart Check?
I'd have to get back to you on that. It's a few million dollars, I believe. But that campaign grew out of in particular, the fact that we were seeing a lot of precious metal scams against retirees, where
minimal investment in protecting those who are most vulnerable to these.
Absolutely. And these are schemes where people are kind of enticed into investing in what they think is going to be this metal that's going to appreciate in value, but the fees and the arrangements end up in them losing their entire investment.
Well, you're right, and I'm sorry to reclaim my time. I'm almost out, but I just want to let you know I'm willing to work with you on ensuring that our seniors and those who may be victims of these schemes actually have access other than just the website. Let me work with you to try and find other ways to put the message out that the CFTC is taking this on with us. So
We'd love to do that, Congressman. Thank you.
Thank you. My time's expired.
Gentlemen, time has expired. Mr. Costa for 5 minutes.
Thank you very much, Mr. Chairman. Per the last question, I don't know if those are actually legitimate schemes or if they're scams, but that's an editorial commentary. Mr. Chairman, I too, with other members, want to get to your digs and get a chance to spend greater time and length, and I apologize, I've been in and out. If some of the questions I posed to you maybe have already been asked. I was checking, I believe your term goes until April 2017?
Correct.
Let me ask you a threshold question. You've said time and time again when I have been here this morning that this is complex. We get it's complex, that the changes are difficult. We get that. We understand the burden you're under with regards to resources. Let me ask you, what do you want to try to get done between now and April 2017?
Thank you for the question, Congressman. It's on several fronts. One is simply improving the resources of this agency so it can carry out its mission. That, to me, is one of the.
I mean, do you have a short list in terms of the rule, in terms of the clearinghouse?
I guess I would have some general areas, but one is improving the resources of this agency. A second is making sure we continue to have very robust surveillance and enforcement, because I think that is, one of our most important jobs.
I think the public assumes that that's. I mean, you're the cop on the street.
Absolutely, but you gotta go in every day and do it, and look at how you're doing it and see what you need to enhance it. You can't just it's not just on autopilot.
And it's ever changing.
It's ever changing, and again, the electronic nature of the markets changes it dramatically, and the need for high-speed computing and greater resources on technology is critical to that surveillance and enforcement.
Do you believe we're going to have the resources?
Today we do not.
If we approve the budget?
Oh, yes. If we had the resources, that would bring us a lot closer. Now, the market's going to continue to evolve. We'll have to see where it goes. But if we got this budget approved, we would be in a much better position.
How concerned are you that the data that you spoke of and that we're all concerned about is being protected?
The data within the Commission? I think, if that's what you're referring to?
I'm talking about the privacy in terms of potential attacks that are taking place daily.
Right. Well, I guess what I would say is I think we have a very good set of systems and policies to protect information at the Commission. I am very concerned, though, about general cyber attack readiness. We've got to make sure our own systems stay up to date.
Does that cause you to lose sleep at night?
Well, I try not to lose sleep over anything, but it's certainly at the top of one of my concerns is the cyber attack risk generally.
I talked about your timeline between now and 2017 in April, and you're talking about the Europeans who I have some interaction with, and their timelines on the implementation of theirs, which is 2017. Are we going to be ahead of them or be behind them as this goes forward?
Yeah, it's a good question. We generally got our rule framework done before just about any other jurisdiction. But there are a lot of things that I think even in the next 2 years I can work out hopefully with the Europeans on trying to harmonize some of these things. As I said before, we're very focused on clearinghouse regulation. We're very focused on the margin for uncleared swaps. You work with the hand that you're dealt. I mean, the fact that other jurisdictions haven't gotten their rules done does pose some challenges, but we can still make a lot of progress.
Well, as it relates to our efforts with the Europeans, and you talked a great deal this morning about your efforts on harmonization, I'm wondering, when we look at the efforts in Frankfurt and other places, do you think there's going to be the level of harmonization between our European trading partners and ourselves as it relates to the operations of the clearinghouses?
Yeah, I think we can get there. As I said, on clearinghouses, we've had a framework in place that I think has worked very well. And what I'm trying to do is enhance that and work out arrangements with the Europeans on that. We've made very good progress in this regard.
All right, my time's just about out, but I'd like to continue the conversation, and I'll get over to your digs, and we'll get a chance to get a better understanding. Thank you, Mr. Chairman.
Gentleman's time has expired. Mr. Allen, 5 minutes.
Well, thank you, Mr. Chairman, for joining us today. And going back to the cost-benefit analysis with regard to the Inspector General's report, balancing the legal and economic issue, I'd like your thoughts on the findings of the Inspector General and how your staff is conducting a thorough cost-benefit analysis with regard to balancing the legal and economic regulatory environment.
Thank you, Congressman. We take cost-benefit analysis very seriously. We're required to do it for any rulemaking. We're required to consider a number of factors. I think we engage in very robust analysis. And I think you've got a commission today that wants to see that analysis done thoroughly and wants to consider that in connection with any actions we take. So I think we're doing an excellent job there, and we'll continue to make it a top priority.
The Commission's proposed rule on position limits contains an attempt to redefine the meaning of bona fide hedging. The proposal appears to exclude many routine hedging transactions that have been used for decades by agriculture and agribusiness hedgers to manage their business risks and that have not been recognized by the CFTC as bona fide. If adopted, this proposal will increase hedging costs, resulting in lower bids to our farmers and ranchers and higher consumer costs. Will you commit to ensuring that our agriculture and agribusiness hedgers can keep the risk management tools that they have used for years?
Well, thank you for the question, Congressman. We're very committed to getting to a place with a rule that implements the congressional direction we've been given, which is to implement limits on position limits to curb excessive speculation, but at the same time to allow for bona fide hedging. There are complex issues in this area. That's why we're listening very carefully to market participants. Reasonable people can disagree sometimes on these issues, but we'll do the best job we can to end up with a rule that balances those considerations.
Well, thank you. Several commodity companies have expressed concern they will be forced out of business of offering swaps to their consumers if the de minimis level lowers to $3 billion. If these companies stop offering swaps, wouldn't that just further consolidate the swap business in a handful of Wall Street banks? Do you think that was intended by Dodd-Frank?
Well, I think Dodd-Frank gave us the direction to create a rule framework that regulates swap dealers. And we've done that. We've set a level. It is, under the rule, scheduled to drop in 2017. But we are also committed to looking at that issue, doing a study of that issue, looking at what the effects would be. And I think the Commission, all the commissioners, will be very focused on taking in that data. And I think any decision we make will be informed by that analysis.
Well, obviously, we appreciate your work and hopefully continue to work to make sure that our farmers and our ranchers get the pricing they need, along with the folks get a chance to compete in this business that you're regulating. And I agree with my colleague, Mr. Scott, on that we're really concerned about access and integrity, and thank you for your work in that area and appreciate your time. It's a pleasure to meet you.
Thank you. It's a pleasure to meet you.
Thanks for coming by and saying hello to me this morning. Mr. Chairman, I'll yield the rest of my time.
Gentleman just back. Ms. Adams for 5 minutes.
Thank you, Mr. Chair. Chairman Mossad, thank you for being here. The CFTC has a very important role in regulating derivatives as part of Dodd-Frank. I represent the 12th District of North Carolina, Charlotte being one of my major cities. And I wanted to bring up just a few issues related to derivatives held by banks in my district. One of the biggest challenges with regulating derivatives is requiring that trading companies hold more cash on hand should the derivative lose value. My question is, how do we bring down the operational cost of trading derivatives through a clearinghouse in order to ensure that traders and financial firms comply with Dodd-Frank?
If I understood the question in terms of how do we bring down the cost of the operating cost of being a swap dealer or clearing, I wasn't quite sure.
Clearing.
Of clearing. We've mandated clearing of standardized products, which I think is a very good way to address risk. It helps us monitor the risk. We're trying to do all we can to make sure those clearinghouses then function in a manner that creates efficiency. We also do a lot of surveillance to look at how that is all operating. The cost of that to the members is driven by a number of factors. Today, for example, for the clearing members, if you talk to them a lot, what you'll hear a lot is, their costs are very affected by the low interest rate environment because, they hold customer funds and low interest rates affect what they earn from that. But we're certainly conscious of looking at our rule set to make sure that firms, to make sure that we balance the regulatory goals of creating oversight for this market, creating transparency for this market, with the costs that's creating.
Okay. What kind of market data is CFTC analyzing when considering its options and moving forward with its position limits rulemaking?
Thank you for the question. We first of all invite any industry, anyone who's commenting to give us data. We welcome data from market participants and other members of the public. So anything we get in a comment letter, we're looking at. We have a staff of economists that also looks at this in our different markets, and we try to get further input from industry participants. So again, we try to make it as data-driven as possible.
Can you tell us when you expect the Commission will act on a rule for position limit?
Well, we're working very hard on it. We don't have a specific timetable. It's something that I will work out in consultation with my fellow commissioners, but we certainly recognize the importance of it. And again, we have a lot of things on our plate, but we are working very hard on this one.
Thank you. And finally, and I think you've alluded to some of this, what concerns do you have with position limit rulemaking? How do you anticipate addressing these issues as we move forward?
Well, it's a very important area. It's also a complex area. We have to balance the need to and the congressional mandate to set position limits so as to curb excessive speculation, with the fact that we also want to make sure commercial companies can engage in bona fide hedging. There are a lot of issues within that that we're looking at, and we've gotten a lot of good public comment on that. So that's why we're taking our time to make sure we do the best job we can to try to get this right.
Thank you, Chairman Massad. Mr. Chairman, thank you. I yield back.
Gentlelady yields back. David Rouser for 5 minutes.
Thank you, Mr. Chairman. And Mr. Chairman, great to have you here before the committee. I, too, have concern about the proposed position limits rule, but you, I think, have answered that probably ad nauseum at this point. So I'm going to skip that one and go to another concern. I want to get your comments regarding the impact of the regulatory requirements on market participants in markets for securitizations and certain exchange-traded products under the Volcker rule, and how these firms will determine the covered fund status of products for which their firms are market makers. I understand there's concern that they may be forced to stop making markets in wide swaths of products due to technical issues in trying to comply with the documentation requirements. And I understand that the financial industry has submitted a reasonable and limited proposal to the regulators related to how they could comply with the Volcker rule, but the regulators have not responded to date. Now, in light of the upcoming July deadline, market makers will need answers in the very near future so they can prepare to comply. Do you have a view on how the regulators will respond? or when this response will come?
Thank you for the question. With respect to Volcker matters, we are working with our fellow regulators because, as you know, this is a rule that is administered by 5 different regulatory agencies. And it's obviously critical that we all try to work together. And, the rules themselves are essentially the same, and it's important that in any kind of issues that arise under the rules, we work together. So I'd have to get back to you on exactly where we are on that request, but I can certainly say that we'll continue to work with the other regulators on it.
Well, I can certainly understand why many in the financial community would be a little nervous about this. Certainty is important, and timeliness is important in this endeavor as well. So appreciate your attention to it. Thank you, Mr. Chairman.
Jim O'Neill's back. Mr. Emmer, 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Chairman, for being here. I just have a couple of basic questions about the budget, but beforehand, I want to go back to the cross-border issue, and I hope I ask it right. By the way, thanks to your staff for their hospitality last week and still processing a lot of information. But there was something that came up about the cross-border mutual recognition issue that you inherited involving our U.S. clearinghouses, exchanges, and reporting facilities versus the European Union. You've been talking about 2017 is when the EU will have their rules done. But I heard a date last week of June of this year is crucial, and I'm just wondering if you can, first, maybe I misunderstood.
Yes. No. 2 different things.
Okay.
And I appreciate the question because it's an important clarification. The 2017 date refers to their rules on trading of swaps on regulated platforms. We've already done a set of rules in that regard. They haven't. They're developing theirs, but theirs are due to be implemented in 2017. The June date refers to the clearinghouse regulation issues. And they had previously said that they would impose a higher capital charge on European firms who did business on clearinghouses abroad that they hadn't yet recognized. The first date was June of last year. They extended it to December. Then they extended December to June of this year. And that's where we are working out arrangements that we hope will lead to their recognition of our clearinghouses as equivalent. Our clearinghouses meet international standards, and we believe they should recognize us. But as part of that discussion, that's where we've been discussing these issues of how to harmonize our rules a little bit more. If we were not to get that done by June, then they would, under the current law, they would impose capital charges, a higher capital charge on their own firms doing business in the U.S. Now, there have been statements by some people on their staff that said, well, we could always extend again. I'm hopeful that, we can resolve this. I think we're making good progress, and we'll continue to work at it.
Well, thank you. And that was the clarification that I was looking for. And maybe it was an assumption based on certain things that were said, but all we heard was very high praise from people in the industry about your leadership and your efforts in not only this area but others.
Well, thank you.
And it's interesting that you've been here for 7 months or 8 months, whatever it is, the number you gave us.
About 8 months, I guess, yeah.
And the extensions have taken place essentially during that time. So
Well,
You're hopeful?
I am hopeful, and I think the European side of this is led by a fellow named Lord Hill, who was just recently appointed to that job, and I have a lot of respect for him. We've had good conversations. Our staffs have had good conversations. I think everybody is working in good faith to try to resolve this. There's a lot of technical nitty-gritty to it, but I think we're working hard at it.
Good. I just have a few seconds left, and you've been here for a long time, but there's a term when I was reading, preparing for this, related to the money that you've requested in your budget for data and technology. You had $45 million would be allocated towards, quote, particular functional activities. And then $63 million would go to data and technology support. Can you just expand briefly on what particular functional activities?
Yeah, absolutely. All that means is that amount is allocated to activities like surveillance and enforcement and examinations, whereas the 63 represents more sort of general tech infrastructure and support and employees that we just don't specifically allocate to another function.
And I'm out of time, but in other words, you do your internal categorization.
Yeah, that's all it is.
Thank you very much, Mr. Chairman.
Thank you.
Chairman yields back. Mr. Aguilar for 5 minutes.
Thank you, Mr. Chairman. Chairman Massey, nice to see you. Another budget question related to my colleague. You received in the Cromnibus $250 million, which was a bump from prior year, but still below what the President had asked. The President in his new budget has asked for $332 million for your agency. What are some of the key areas to fulfill your mission that increased funding will go to? What's your prioritization level when it comes to that funding level?
Thank you for the question, Congressman. A couple of things. Surveillance, enforcement, general data and technology expenditures, and examinations. Let me talk about each one just a little bit, if I can. Surveillance, it's just so critical today, and it's just so much different than it was several years ago when, you might be able to watch the physical trading pits and see if someone pulls their earlobe or something to know whether there's some kind of collusion going on. But today, we're taking in reams of data in the E-mini, the S&P 500 E-mini contract, which is one of the most traded contracts on CME. There's probably 700,000 trades a day. But on top of those trades, there's lots of order messages that are bids, orders. A lot of those are canceled. Now multiply that by the fact that we've got 40 physical commodities, we've got interest rate futures, we've got equity futures, we've got currency futures. Each of those markets is different, and you can start to appreciate the volume of data we have to take in and analyze in order to understand what's going on in these markets. So a lot of our budget is focused on enhancing those surveillance operations, enhancing our overall data and technology. The enforcement area is another key priority. There's nothing more important than robust enforcement in terms of maintaining the integrity of these markets. And we're looking at activity that ranges from the types of Ponzi schemes that people are traditionally familiar with, that unfortunately there's a lot of them that still go on. We had a case that led to someone being put away for I think about 16 years recently for a Ponzi scheme, to collusion among some of the world's largest banks to fix foreign exchange rates, to spoofing, which is a use of high-speed trading. We really need to up our enforcement activity. We need to increase our examinations. Simply with respect to cyber risk alone, we need to be able to make sure we can examine this critical infrastructure of clearinghouses and exchanges. And a lot of that is, just making sure that they're doing what they need to do to be ready for a possible cyber incident. So those are some of the main areas.
I appreciate it. You have 3 offices: Kansas City, New York, Chicago.
That's correct.
Think you need to, in order to meet those priorities, do you need to expand your geographic footprint?
No, I wouldn't do that. I would just, stick with what we have, and I think it works very well. Our Chicago office obviously is very useful in terms of some of the big clearinghouses and exchanges being there. But I think our setup works well from that standpoint.
Appreciate it. With respect, shifting gears a little bit to trade, given your extensive knowledge and experience in the Asian markets, have you been involved in the negotiations related to TPP?
No, I have not. That's really outside of my area, sir.
Okay. Do you anticipate that TPP could assist in your efforts on cross-border issues?
Well, the regulation of derivatives has really been outside of TPP, so I don't know that it would have any direct impact. I was over in Asia recently, though, very focused on our set of issues, and I had a lot of good meetings with our Asian counterparts over there. I think we're making good progress. The Asian jurisdictions, in many ways, in some cases, are kind of waiting to see what we do and what Europe does on some of these issues. On other issues, they are moving forward. But I think we're building good relationships, and we'll be able to work together well.
I appreciate the answers. Mr. Chairman, I'll yield back.
Chairman yields back. Chairman Massa, I had one follow-up question. Your colleague, Chris Giancarlo, recently issued a white paper. He pointed out something that when the rules were being put in place with respect to swap execution facilities, that we had no shortage of conversation with your predecessor. The law, Dodd-Frank law, specifically says that with respect to swap execution facilities, they can trade, or trades are permitted through any means of interstate commerce. Appeared to be a pretty broad definition, and yet the rule really only allows 2 methods of execution and or trading. And we've got buy-side folks and sell-side folks that are all complaining about the prescriptive natures of that. Any plans to revisit that rule?
Well, thank you, Mr. Chairman, for the question. I welcome Commissioner Giancarlo's white paper. I think it was very thoughtful. I appreciate the time he spent on it. And he and I have had good conversations about a lot of these issues, as I have started to have with some of my other fellow commissioners also. I guess I would say I'm not in favor of throwing out the rules and starting all over, but I am open to looking at how we can fine-tune and improve the rules to enhance trading. I think it's important to remember what our goals are in this. We're trying to bring this trading out of the shadows. We're trying in particular to create pre-trade price transparency, and I think that should inform our judgment when we think about what's an appropriate method of execution. I think the other thing to remember is this is all new. We're all learning, but swap volumes are growing on these platforms, and people are building the technology to improve that. And we're working with industry participants as we all learn. I mean, we've done some adjustments, for example, on package transactions to make it easier to do package transactions, where you've got something that's maybe traded on the CEF, something that's not, but they're linked. And we'll continue to do that.
All right. Well, I guess this is a dynamic arena. And
I'm sorry?
A dynamic arena, in general, dynamic. And that a rule that was put in place that looked like the right thing, and this would apply to any of the rules out there, but as we gain experience with any of them, what I've been encouraged by is the fact that you've already started the process of, if a rule doesn't work, that you're open to the suggestions of how to either decrease the prescriptiveness necessarily in the rule in this particular area or the others. Anything else in the white paper that jumped out at you that would trigger something that you want us to talk about?
I think there are a few things that we're looking at and thinking about. I I think there's some pretty complex workflows that you look at in terms of what happens once something is executed. How does it then get affirmed? How does it then get cleared? What happens if there's an error? Should we be more flexible on errors? He made a very interesting suggestion about licensing people who trade swaps. So I think there's a number of issues, and I look forward to continuing to talk about those with him.
All right. Ranking Member, have a closing statement. Well, Mr. Chairman, congratulations on your first time here. You wore everybody out, apparently.
Thank you.
I would like to acknowledge that you set the bar pretty high for concise answers, which, unlike others who like to filibuster their answers, it exposed you to a lot more questions from the individual members by not taking up the full minutes with your answers. So I hope that more folks take your example and that you don't go the other way and filibuster your answers. Because
well, thank you, Mr. Chairman.
Impressed with the conciseness of your answers. Under the rules, the committee of today's hearing. That's my opening statement. Thank you again for being here. Thank your team for last Friday afternoon, and I think several of the members will be taking you up on your offer to come, because we all, the more we know about each other,
absolutely,
the better we are at whatever those differences are. We don't let them grow out of proportion to what they really should be if we're trusting each other, because we've got a basis of relationship. So, again, thanks. Under the rules, the record of today's hearing will be made open for 10 calendar days to receive additional material, supplemental written responses from the witnesses to any question posed by a member. This hearing of the Committee on Agriculture is now adjourned.
Thank you.